The Fifth Circuit, who doesn't cover New York, but issued a decision that struck down the Department of Labor's 80-20-30 rule and enjoined application of or enforcement of the rule nationwide. This generated, for good reason, a lot of publicity. It made the mainstream news, not just legal periodicals. And so we were getting a lot of inquiries. A lot of clients said, well, we don't have to worry about 80-20 any longer because of this Fifth Circuit decision. And so the important thing that everyone should and hopefully is aware of is that 80-20-30, the federal construct, has been enjoined by the Fifth Circuit. New York State, in the hospitality wage order, which is the set of regulations that governs the wage and hour practices for your industry, has its own codified 80-20 rule that you are still very much required to comply with. So even before the Fifth Circuit enjoined 80-20-30, the concept, I find, and maybe Felice I'm sure finds as well, there's a lot of confusion as to what 80-20 actually means and the consequences of not complying with 80-20. So what 80-20 really is, in its most simplest terms, it's a question that evaluates whether you're able to take a tip credit with respect to the wages of an employee. And so if you fail 80-20, quote unquote, if you fail 80-20, meaning whether it's 80-20-30, 80-20, the idea is that you have to pay that employee at least the full minimum wage for under federal law. It was a portion of the shift. The 80-20-30 concept was that you only had to pay them the full minimum wage for the periods of time when you are outside the 30-minute window. But in New York, it's for the entirety of the shift. You are already complying, whether wittingly or unwittingly, with federal 80-20-30 because you are paying all of your employees above the federal full minimum wage. So really, now, in current day, 80-20 is still an issue that you have to be concerned about, but you will have to be concerned about New York's 80-20 law, which doesn't have the 30-minute component. And New York's 80-20 rule is that if you spend 2 hours or 20% of or more than 20% of your shift engaged in non-tip producing or tip generating work, that you need to be paid the full minimum wage for the entirety of your shift. So that means, yeah. So go ahead.
So nothing has changed in New York. Nothing has changed in New York because of this federal ruling in Texas, because we still have the New York regulation, which is more onerous than the federal law, because as Adam just said, you can't pay someone for half a shift doing non-tip producing work and the other half of the shift tip producing work. If part of the shift, 2 hours, 20%, whichever is the lower, is non-tip producing work, you have to pay at least the minimum wage, which is now $16 an hour. Do I have that right? In New York, for the whole shift.